Supreme Court of India Baljinder Singh alias Ladoo and others vs State of Punjab decided on September 25, 2024 SCC Online SC 2622 Facts of the case. The prosecution case was that SHO, police station, upon receiving information on December 12, 1997 from prosecution witness 2, Dr. Brij Mohan of the Civil Hospital, reached the hospital and recorded the statement of prosecution witness 3, victim Puran Singh at Bola. Prosecution witness 3 recounted that on the morning of December 12, 1997 around 9 a.m., he was standing outside his residence near the Chowk, when accused number 1, son of accused number 4, came riding a scooter from the direction of the Gurudwara and bumped into prosecution witness 3, causing minor injuries to little and the ring fingers of prosecution witness 3's right hand. In response, prosecution witness 3 slapped accused number 1, who in return hurled pejoratives at prosecution witness 3. Indignantly, prosecution witness 3 again slapped accused number 1. Upon hearing the commotion, prosecution witness 4, victim Jit Singh, deceased victim Karam Singh, deceased victim Ladoo and prosecution witness 5, victim Jaga at Jagjit Singh intervened and separated prosecution witness 3 and accused number 1. Within 15 minutes of such altercation, accused number 1, accused number 2 and accused number 3, all sons of accused number 4, armed with dangs and sofas, accompanied by accused number 4, who wielded a 12-bore double-barrel gun, and accused number 5, armed with a dang, assembled on the street and while raising exhortations, lalkaras, attacked prosecution witness 3, prosecution witness 4, prosecution witness 5, and the deceased numbers 1 and 2. Accused number 1, accused number 2 and accused number 3 began brick batting and accused number 4, with an intention to kill, fired 5 shots at the victims, resulting in minor injury to prosecution witness 3 and serious injuries to prosecution witness 4, prosecution witness 5, and the victims. Consequently, FIR under sections 307 and 148, IPC read with section 149, IPC and section 25 and 27 of the Arms Act. Deceased number 1 breathed his last on December 13, 1997. Consequently, offense under section 302, IPC was added to the said FIR. The trial court, finding the appellants in A5 guilty, convicted them for the offenses and sentenced them. High Court dismissed the appeal. Findings of the court. The sole issue that we are tasked to decide is whether the conviction of accused number 1, accused number 2 and accused and the sentence imposed on them warrant interdiction. It is worth indicating that prosecution witness 3, prosecution witness 4, and prosecution witness 5 are injured witnesses, or injured eyewitnesses. In this case, the sworn testimonies provided by injured witnesses generally carry significant evidentiary weight. Such testimonies cannot be dismissed as unreliable unless there are pellucid and substantial discrepancies or contradictions that undermine their credibility. If there is any exaggeration in the deposition that is immaterial to the case, such exaggeration should be disregarded. However, it does not warrant the rejection of the entire evidence. Therefore, the suspicion raised by the appellants regarding the genesis of the case is rendered unfounded. The severe nature of the attack by accused number 4, assisted by accused number 1, accused number 2 and accused number 3, inflicting serious/fatal injuries upon the victims, leads to the inference that the appellants came with an intention to kill in retaliation of a previous altercation. Hence, the prosecution version is indeed reliable, while the depositions of defense witnesses 1 and prosecution witness 5 established that a 4's daughter filed an FIR against the son of Bur Singh and that accused number 4 was known for reading Sarah at weddings. The burden of proving an assertion that accused 4 was on his way to the Sarpanch's son's wedding lay upon accused number 4, which would have been more credibly substantiated by the testimony of the Sarpanch himself, as rightly noted in the High Court's judgment. In the absence of testimonies from the Sarpanch and the daughter of accused number -4, the appellant's claim of being falsely implicated remains unsubstantiated and, therefore, deemed unreliable. Section 34, IPC underlines that when a criminal act is done by 2 or more persons in furtherance of common intention, each of them is liable for the act done as if it were done by him alone. We are of the view that there cannot be a fixed timeframe for formation of common intention. It is not essential for the perpetrators to have had prior meetings to conspire or make preparations for the crime. Common intention to commit murder can arise even moments before the commission of the act. Since common intention is a mental state of the perpetrators, it is inherently challenging to substantiate directly. Instead, it can be inferred from the conduct of the perpetrators immediately before, during, and after the commission of the act. In the present case, the appellants, who are related by blood, arrived at the crime scene armed with a 12-bore double-barrel gun, dangs, and laddis within 15 minutes of the initial altercation, and subsequently attacked prosecution witness 3, prosecution witness 4, prosecution witness 5, and the victims. During this attack, accused number 4, the father of A1, raged by the incident of prosecution witness 3 slapping his adult son A1 and the pursuant altercation, fired with his gun at prosecution witness 3, prosecution witness 4, prosecution witness 5 and the victims. Thereafter, all the appellants fled together carrying their weapons. In view of such conduct of the appellants as mentioned above and in the light of interpretation of Section 34, IPC, it would be relevant at this juncture to consider Section 464 of the CRPC. On its plain terms, subsection 1 of Section 464 clearly indicates that no finding, sentence, or order by a court of competent jurisdiction shall be deemed invalid merely on the ground that no charge was framed or on the ground of any error, omission or irregularity in the charge including any misjoinder of charges, unless, in an appeal, confirmation or revision, a claim of failure of justice has been substantiated. We have no hesitation to hold that based on the above parameters, the appellants have fairly and squarely failed in their pursuit to demonstrate any failure of justice. It has been rightly pointed out by the trial court that the prosecution's case is not that people from the surrounding locality gathered at the time of the incident. In the light of the aforenoted decisions of this court and upon careful examination of the testimonies of prosecution witness 3, prosecution witness 4, and prosecution witness 5, along with the relevant other evidence on record, the prosecution's case cannot be dismissed solely on the ground of the absence of independent witness. The appeal is bereft of any merit and, therefore, stands dismissed.